So I just filed a limited entry of appearance in her case.
Okay, just 1 second.
I apologize. I can't hear anybody.
Okay.
Welcome to monitor. I had a computer screen just break on me and I had to switch something around, Your Honor. I apologize. I'm trying to get my tech support. Because the speakers are muted.
You've reached the McGarren Law Firm. Please.
Your Honor, I will try to call in on my phone.
Okay.
For the audio separately. Can you hear me? Let me
Yes.
see if I can figure out how to do that. 1 second. I'm going to mute for.
AVLF lawyer, will you give me your name again, please?
Darius Woods.
I think I'll be on my phone for audio, so you'll see a separate login. I'll try that. Can you hear me now?
Yes.
Okay.
Can you hear us, most importantly?
Yes, I can.
Okay. All right. Well, then let me just start by saying good morning, everyone. This is Lavonda Moore versus Mr. Jin Woo. And this is 12, let's see, maybe that's one of our questions. Which civil action number we're actually proceeding under. I'm going to give both of them. One is 2020 CV 343451, and one is 2022 CV 362752. Today is April 14th, 2022. I've put these proceedings on the court's YouTube live stream channel. The reason that I have done that is because we actually have a criminal jury trial proceeding in our courtroom. I'm actually in chambers in order to meet our obligation, which we take very seriously, to keep the public's business open and accessible to it. We do have a YouTube live stream channel, which allows for public access through the court's website. I'll make sure to discontinue that live stream before we finish. And that should, and I say should, have the effect of not preserving the YouTube hearing forever. I think once we stop it, it stops. Now, not sure which case number we're proceeding under. I'll let Ms. Moore and her counsel address that. But we're here on a motion to vacate a writ of possession. Either, I think there are two filed. And so Ms. Moore or excuse me, Mr. Woods, I'll let you proceed.
Thank you, Your Honor. So we're actually dealing with both cases. It's my understanding that the 22 case was filed because Ms. Moore wasn't aware of the writ of possession until after 30 days. So they required her to file another case in order to file a post-judgment motion. So that's what the 22 case is about. But we're mainly here today because in 2021, the parties came before your courtroom and they entered into a consent agreement that said that Ms. Moore lease would be terminated and she would move out of the property by May 31st of 2021. After that May 31st, 2021 date, the parties continued to operate in a landlord-tenant arrangement, although a new lease agreement wasn't signed. It was the understanding, at least Ms. Moore's understanding, that they were going to be month to month. And we even have some emails that I saw this morning from Mr. Wu alluding to the fact that Ms. Moore would be a month-to-month tenant. Fast forward back to, I believe it was February 24th of this year, Mr. Wu filed an application for a writ of possession without giving any notice to Ms. Moore, without making a demand for possession. Somehow that was granted, and 2 days ago, the writ of possession was executed. So we're mainly here today because we believe that Mr. Wu waived his right to terminate her lease without going through the proper dispossessory process when he failed to seek a writ of possession in May 31st of 2021. He waited about 10 months in order to get a writ of possession, despite Ms. Moore continuing to pay rent and continuing to meet her obligations as a tenant. She received absolutely no notice at all, yet she was evicted without proper notice. And we believe that's just a violation of Georgia law and the dispossessory code.
Okay, what do you want me to do?
Well, we first want you to vacate the writ of possession. I think we'll start there, even though Ms. Moore does not want to move back into the house at this point. She does want to pursue damages on a separate case for an illegal eviction. But I think a start is to vacate the motion, the writ.
Okay, all right, Mr. McGarren.
Yes, Your Honor. I was before you at the original hearing, and I know you handle a lot, so I'm sure it might be hard to recollect everything, even myself. I don't remember every detail, but this is sort of the gist. There was a back and forth. Mr. Wu wanted to move forward and put his house up for sale. There was a claim by Ms. Moore, a separate lawsuit saying that he didn't repair, and we all kind of worked it out. We came to a consent order, and Ms. Moore had asked for more time, and Mr. Wu reluctantly said that that's fine. She would need time to find a place. She had a child on the way. So an order went into place that, that a writ of possession, he could request one after May of last year. So when that time came, the way I understood it, Ms. Moore again was not ready to move. And she just automatically, I guess, electronically paid. And, there was discussion of a new lease at a higher rate if she really wanted to stay, but he was kind of caught because she's like, I have no place to go. And then she kept talking about, well, I want to buy the place. So there was even an email, and some of that emails that were sent over, she was trying to get a loan. I think that's what she wanted to do. But there's multiple times he said, you got to move out. I don't know what to do with this. And so we don't view this as a new lease. He made it clear in his messages to her, there's no lease. This is a holdover. I'll work with you month by month, but that writ, that order was not vacated. He had the right to file for that writ. They didn't enter into amended consent order. And so what happened, and his testimony will be that in February, he accepted, I guess, Ms. Moore paid $800 in, which was the original thing. And he said to her, look, he let her know in February, I think he applied middle of February, I'm applying for the writ. And she, I think, even said, well, let me see if I can get some help through this other agency to be somewhere. Let me apply. I need at least 10 days, something like that. But make long story short, February is when he applied for it. He told her verbally, is what he'll testify, that she was aware of it. And then it was executed just the other day. So it was about 2 months. I mean, best case scenario, Ms. Moore had, a 60-day. But this is like no good deed goes unpunished from his perspective. He's like, okay, he could have kicked her out or evicted her or asked for the writ back in May, but she came to him pleading. And then this went on for months. Then in July, are you moving out? Are you moving? Do I need to do the writ? That was kind of the conversation. So he's kind of like, nobody came back to the court to amend it, including Ms. Moore. So the order had not been, in the same term of court. There'd been no motion to set it aside. That right still existed. So that's, I guess, Mr. Woods.
What concerns me, and Mr. Woods and Mr. McGarren, I think what concerns me really is the court's jurisdiction at this point. Because essentially this is an appeal of an order that was entered on February 24th, 2022, and that being the writ of possession. And this new case was filed on March 30th, 2022, and without any application for discretionary appeal, as I understand it. I don't know if this is a case that would fall under the application proceedings for the appellate court. I suspect it might. I don't know if you can appeal an appeal through a direct appeal route. But on February the 24th, 2022, the court entered an order which I think at this point is the law of the case. And I understand that a separate action has been filed to vacate that order, but I think that's a collateral attack from a case that could have been directly appealed. I think it's a jurisdiction. I don't think this court has jurisdiction to vacate the writ.
Well, there's also mootness, Your Honor, I would say, in the sense that, the writ's been executed, and by, I guess, counsel's just statement, she has no intention to move back in. So it's moot along that basis.
Well, Mr. Woods, if you could address, I mean, I'm not, I think that everyone had a complete and thorough understanding of where we were last year. I mean, there was an agreement between the parties, and there was an order that said, you can apply for the writ. And there was an order on February 12th, 2021 that said no further notice, essentially no further notice is necessary. Now, I guess maybe you have a legal question as to whether that is, whether that's violates landlord-tenant law, but at that point you could have appealed that order in February of 2021, or you could have appealed the writ that was entered on February 24th. I just don't think I have a case.
Yeah, Your Honor, if I may be heard, I think this case is really about a mutual departure under 3-4 OCGA. I believe it's 344.
Which would have been a great argument if you had gotten here in time.
And the thing is,
I don't think it would have been a great argument, but it would have been an argument.
Your Honor, the thing is that Ms. Moore was completely unaware of Mr. Wu's application for a writ of possession.
Was she not in the court's e-file system?
No, she is not a part of the court's e-file system. She never received notice of the writ of possession until Mr. Wu texted her. And he didn't text her. And if you can give me an opportunity, Mr. McGarren, he didn't text her until after a judgment was entered against him through code enforcement. So back in February, Mr. Wu had to pay $700 for not making proper repairs to the property. And after that, he filed for a writ of possession, and that writ of possession was granted. So I really think I agree as far as the procedure history of this case and where it is procedurally, but Ms. Moore couldn't file a motion to vacate when the writ of possession was requested, or file a response, because she was completely unaware of it. So the reason why that second case was open is because once she found out about it, it happened to be 30 days after the judgment or the order was already granted. And once she found out, she immediately filed that notice to vacate or motion to vacate. But the fact is that they had a month-to-month agreement. Outside of that consent agreement, when Mr. Wu agreed to allow her to stay past that May 31st date, he waived his right of termination. He had to go through the proper dispossessory process. Now, even if he says, okay, we verbally agreed that we didn't have to pursue the dispossessory process because it was our mutual understanding, under 4472, you can't waive rights under Article 3 of 4472. And that's what Mr. Wu is alleging. That's the only thing he could allege, is that they somehow waived the rights for him to pursue the proper dispossessory process. And that just isn't the case here. You can't waive those rights. He had to go and file a new dispossessory case in the Magistrate Court of Fulton County to get the right to evict her. And he didn't. He went through the Superior Court case because he understood that Ms. Moore would never have notice of this. He understood that she was a pro se tenant. She was representing herself while he was represented. This isn't.
Wait a minute, stop, Mr. McGarren.
Respond.
Mr. McGarren, stop. We're gonna let Mr. Woods talk now.
What's that? I'm losing your honor.
We have text messages, emails. There's an email from recently as August of 2021 where Miss Moore reached out to Mr. Wu and said, hey, I need proof that I reside here. And in any email, he states that, okay, we don't have a new lease agreement, but you're a month to month. Under Georgia law, if someone is a month-to-month tenant, which is a tenant at will, a landlord must give 60 days notice of termination, and they still must follow the dispossessory process. What Mr. McGarren is arguing is that even if Mr. Wu tried to evict Ms. Moore 2 years from now, that he would still be entitled to evict her because it was a consent agreement entered into on May 31st, 2021. That there was no waiver at all, and that's not accurate.
Okay. All right.
Your honor, if I can just make one short comment.
Sure.
Just so you know, I found out about this yesterday. I hadn't researched the jurisdictional aspect of it, so I appreciate the court, looking into that first and foremost. I don't disagree with the court. What my whole take, and I've represented tenants and landlords over my career, and I think what happened here was we were here and there was a writ of record at any time he wanted to pull that pin, and I think he was trying to work with her. And he'll tell you, there's messages like, are you moving out? Are you moving out? Which goes contrary to his argument that it's a, forever lease. At some point, I guess the point is that was kind of the situation. I have this order where I can ask anytime, but go ahead, stay another month or stay another month because she paid it. He didn't he wanted to work with her. She had a child. So it's like no good deed goes unpunished, but at some point he had to move forward. Now, if they want to take a separate action to say the writ wasn't good, I guess I think that I don't think the order can be, at least by this court, as the court said, be vacated, especially in this late time.
Okay, let me just find out one thing from a computer standpoint, and I'll be right back.
Okay.
Hey, Jessica. So she's not on the of our order of February 24th. Yeah. That's all. Okay, well, I've checked with our staff attorney because this issue of not receiving notice of the February 24th writ of possession, which I think is kind of the central feature here, because otherwise she's saying, I didn't know to appeal, which obviously we hear a lot. But I believe that the obligation is on her to keep abreast of court proceedings in a case that she is a party to. And I don't think this court has jurisdiction, certainly in the 2020 case, to set aside its writ of possession. Again, I think Mr. Woods or Mr. McGarren may have touched upon the issue of, so what happens to the 2022 case? Does it proceed? And if it's simply on vacating the writ of possession, I'm not sure I understand pathway to do that from an entirely different case. I think it becomes a collateral attack issue.
And Your Honor,
And I'm not trying to be ugly. I
Yeah,
mean,
yeah.
I'm just looking at it from a procedural point of view.
Yeah, and I hear you on as far as the 2022 case. It was my take that a whole new case didn't need to be filed in order to file a motion to vacate, that the motion should have been filed in that 2020 case instead of filing a brand new case. When
Right.
Ms. Moore went to the clerk's office made her file the 2022 case, and they said that they would refer it back to the 2020 case, and that was the only way that she can file an amended motion. But in addition to that, I do want to just express that Ms. Moore was unaware of a possible writ of possession. It was her understanding that they were they were in a month-to-month situation, that he would not be going back into an old case from 2021, from 10 months prior, to try to issue a writ of possession without giving her notice, at least 60 days notice that he was intending to terminate her lease. And in addition to that, going through the proper dispossessory process, which he failed to do in this case. But I understand what you're saying, but I do just want to express that this is Mr. Wu coming back after he allowed Ms. Moore to stay in the house for 10 months. And after he got a judgment against him from code enforcement for not repairing the property, then he filed for a writ of possession without giving her any notice. She had no reason to expect that a writ of possession could be filed in a prior case that was 10 months old.
Okay. So I think what you're arguing, Mr. Woods, and stay with me for a minute. I think what you're arguing is that subsequent to May 31st, there was a parole contract of landlord tenancy under 44-7-2. So you're saying, you had your judgment said X, which the judgment, good, bad, or indifferent, definitely said that Mr. Wu could apply for the writ of possession at any time. And I think it says something like that. The final order that I entered in the 2020 case on February 12th, 2021, no further notice will be required to give Ms. Moore termination of her lease. If she fails to make payments, that the landlord can request an immediate writ of possession. That's not untypical for orders entered in the magistrate court in landlord-tenant matters. Is it, Mr. Woods?
I think it is. I think it's not typical for an order like that to be issued. Specifically, that order states that he can automatically get a writ of possession if she fails to pay rent. It doesn't necessarily speak to the issue about the termination of her lease. And even if her lease was terminated and they entered into another agreement or departed from that consent agreement when he didn't properly execute or request a writ of possession, then I think he waived his right to terminate. And I also want to note that he applied for a writ of possession in November of 2021, but that request for writ of possession was denied. So that's why this is all confusing on Ms. Moore's end, because the original writ of possession, which she also didn't receive notice about from November of 2021, was denied. And then the next one was to come. If we were to say that any landlord can just have to maintain a right to terminate whenever they feel like it, that wouldn't give any tenants, or specifically Ms. Moore, any kind of heads up. Just imagine.
But she agreed to it. Did she not? She agreed to it. In paragraph 3 of my order of February 12th, 2021 in the 2020 case, it says the matter was scheduled for a final hearing and discussions before the court. The parties agreed.
Yeah, but
so I don't know.
44-7-2, you can't agree to waive your rights. You can't. This is about a future contract. So they established a new contract. it was a new quasi agreement under 344, OCJ 344, which says that if you waive, and I have the specific citations here for you, it says a party may by his conduct waive a legal right where there's evidence that the intention is to waive. To waive is what a party does or forbears to do. So because he forbeared to actually exercise his right to get a writ of possession, he waived his legal right to get that writ of possession by allowing her to stay 10 additional months. What should have happened is that Mr. Wu, and I understand his counsel is taking the position that he was just being, considerate and kind, but what Mr. Wu should have done by May 31st, if Ms. Moore didn't move out, he should have filed an eviction case or requested a writ of possession from you at that time. Mr. Wu can't wait 10 months in order to request a writ of possession after he's been accepting her rent, after he's still been communicating with her as if they had a landlord-tenant relationship. This consent agreement can't cover a future contract, even if it was an oral contract. They created a new quasi agreement. And that's what the issue is here, that there's a new agreement. It's not about this consent agreement, because that he waived his rights to enforce any terms of that consent agreement when he allowed her to stay for 10 months.
Okay, here's where I think we are. And Mr. McGarren, I'll certainly give you an opportunity to respond, but where I think we are is perhaps, and this is a real perhaps, Mr. Woods, but you're doing a great job. Perhaps there is an argument as to the subsequent agreement, if any. However, I don't think I have jurisdiction to set aside the writ in the 2020 case. Mr. McGarren, you got anything to offer?
Yeah, I know we're not hearing evidence, but the other side to that would be that she did, in fact, have notice. There was talk about moving out. In the text messages, Your Honor, there's talk if you really want to stay, then, the 800 is way too low, do 1,200. Her saying we're not going to pay 1,200. But the thought, I guess, if we look at this from a public policy standpoint, do we want a landlord who enters the consent order to have to throw somebody out if they have children? And this is kind of what happened, because she kept saying, I want to buy it. I want to be in there. So if anything, the 10 months, and I don't know if the court recollects, but we negotiated to May when he wanted her out then. We gave her all those extra months, and then I have nowhere to go. So I guess what counsel's saying is, well, since you didn't go ahead and you didn't take the cruel approach, you should be bound on being in trouble for later on exercising it. I mean,
the issue really is, did Mr. Wu have to file a new writ of possession? And all I'm saying is I don't have jurisdiction to set aside the writ of possession that was granted in the 2020.
I think a new consent order would have made more sense. If Ms. Moore had consulted counsel, then that would be the way, because that right remained. And it has not been. Well,
there may be something that remains in the 2022 case, but it's not a vacation of the writ of possession in the 2020 case.
It's also moot. Once the writ has been exercised, how do you vacate? Well,
if it was wrongfully exercised, that's another story. But y'all are smart. You'll get to that part. Okay. Thank you, Mr. McGarren. Will you take an order and submit that to the court and copy Mr. Woods and Ms. Moore?
Your Honor, I just found out about this in the middle of it, and I am working on the culmination of a case I've been working on for 6 years that involves several $1 million that I have to work on, probably the biggest case of my career. So I am slammed for the next week, but I will try my best. If not, do you mind if I get it to you a little bit later? Or is it just denied?
It's denied.
Okay.
Right. Okay.
Maybe Monday, Your Honor, if that's all right.
Okay, Mr. Woods, I don't want to discourage you. I think you've done a wonderful job. I hope to see you again. Thank you very much. Atlanta Volunteer Lawyers Foundation is an unbelievable asset to the community. Thank you. Anything else?
No, Your Honor.
Okay. All right. Good luck, Ms. Moore. Thank you.
Thank you.
And